Today, I am delighted to now turn to our guest keynote speaker, Shannon Bream, who is now serving as the anchor of Fox News Sunday. Since beginning her career at Fox in 2007, Bream has provided coverage throughout every major political cycle, anchoring both midterm elections and the most recent 2024 presidential election night. Notably, during the previous presidential election cycle, she covered the assassination attempt against Donald Trump and also landed an interview with vice presidential candidate Tim Walz. In addition to her work anchoring Fox News Sunday, Bream also serves as the chief legal correspondent of the network, where she has covered major Supreme Court decisions, including the Defense of Marriage Act in 2013 and the overturning of Roe v. Wade in 2022. She has also covered the confirmation hearings of Justice Amy Coney Barrett, the nomination of Justice Sonia Sotomayor, and the retirement of Justice Stephen Breyer. Outside of her role at Fox, Bream is host to the podcast called Livin' the Bream, and an author of several books, including Finding the Bright Side, The Art of Chasing What Matters, The Women of the Bible Speak, Mothers and Daughters of the Bible Speak, and The Love Stories of the Bible Speak. 3 of these titles appeared on the New York Times bestseller list. Before beginning her work as a broadcaster and journalist, Bream worked as a lawyer in the state of Florida after receiving her JD from Florida State and her BA from Liberty University. We are very grateful that you have joined us here today. Please join me in welcoming Shannon Bream.
Thank you so much. I'm honored to join our fellow speakers. I enjoyed each of your remarks so much. Thank you for sharing with us. The first time that I ever took to a stage to share my thoughts, any of them on the Constitution, it was a much different setting than this one. It was 1976, yes, I'm dating myself, and my school was doing a bicentennial play about the founding of America. Just before we were set to take the stage, the little girl who was set to play Betsy Ross in this play, happened to be the star of our show, decided that she was too sick to perform. Now, whether it was anxiety or whether it was actually a physical issue like a tummy ache, I do not know. But I do know that the kindergarten teacher thought of someone she knew who would be too much of a ham to be worried about not knowing a single line of the Betsy Ross lines, who would also be willing to step into the spotlight. And I have very vivid memories of my mom standing just off stage in a very loud stage whisper, feeding me every single line as I rocked back and forth in this chair, doing a very exaggerated sewing loop as if I was working on one of the first flags to ever represent our country. I was too young, obviously, to comprehend it then, but that was the beginning of my love for the Constitution, a document that, while we've all talked about as imperfect, has guided us through many treacherous times and always provided us a way to work toward a more perfect union when we have gotten it wrong along the way. Now, some of you here may have your doubts. Maybe your faith has been shaken by some of the recent challenges to our system, and you wonder whether the foundation that we created decades, centuries ago will actually hold firm. If that is where you are today, I want to encourage you to know you're not the first to feel this kind of anxiety about the survival of the constitutional underpinnings that shape our legal framework and ensure the continued existence of our great democratic experiment. Ben Franklin said this to his fellow delegates at the close of the 1787 Constitutional Convention, quote, "I confess that I did not entirely approve of the Constitution." An astute observer of his fellow countrymen, Franklin added, quote, "I doubt too whether any other convention we can obtain may be able to make a better constitution, for when you assemble a number of men to have the advantage of their joint wisdom, you inevitably assemble with those men all their prejudices, all their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly can hardly to expect to have a perfect production." Now, Franklin was far from alone in that sentiment. The governing framework for the new nation was the result of hard-fought compromise, but nobody got everything they wanted. Among those who supported ratification were Federalist Alexander Hamilton, who said, "No man's ideas were more remote from the plan than mine were known to be." And Delegate James Wilson said, "If my wish had prevailed, it would certainly have been altered." George Washington, president of the 1787 convention, in a letter to General Henry Knox wrote this, said, "I'm fully persuaded it is the best that can be obtained at the present moment under such diversity of ideas as prevail." Now, since then, of course, our nation has only grown more diverse, with a longer list of competing priorities and near constant challenges arising as society does progress. Some of these things our forefathers could not have possibly predicted. Over the years, in fact, in the immediate aftermath of ratification, until this day, and probably forevermore into the future, the Supreme Court has had to revisit decisions as it measures ever-changing facts against the Constitution, and Congress has made revisions more and more often when more clarity has been needed. So, isn't it all the more remarkable, as so many of you have pointed out, to see that when the founding tenets have been tested, missteps or misjudgments have been corrected, amendments have been added to allow our republic to grow within the bounds of this law of the land. This has always been the case, as predicted and fully expected by those who crafted and approved the U.S. Constitution. It should come as no surprise to us, these alterations, the testing, the course corrections, these things should actually reaffirm just how wonderfully crafted our founding document is. Over the years, the court has worked to protect our liberties, reversed itself on really consequential subjects, and refined application of laws to facts as the basic tenets of the rights secured to us have been tested. In addition, Congress, together with the states, has added 27 amendments to our Constitution. This is the very system that the Constitution's drafters provided for, as it was clear to them from the start that amendments would be critical to this document and necessary in order for it to survive. As Ben Franklin rightly assessed, the U.S. Constitution was and is an imperfect document. Alexander Hamilton, in what we now know as Federalist Paper number 85, or his concluding remarks arguing for the ratification of the Constitution, worked to assure his audience that the amendment process laid out in what he called the fifth article of the plan was sufficient to address shortcomings and future unknowable challenges. In fact, he saw the amendment process as a safeguard, not a failing of the Constitution. George Washington, too, in a letter to Benjamin Harrison, wrote, "I wish the Constitution, which is offered, had been made more perfect, but I sincerely believe it is the best that could be obtained at this time. And as a constitutional door is open for amendment hereafter, the adoption of it under the present circumstances of the Union is, in my opinion, desirable." There was talk of amending the Constitution before it had even been ratified, and that continued in the months and years that immediately followed. In a September 1789 letter to Madison, Jefferson wrote this, "I repeat my doubt whether the Constitution devised by the Convention does not contain within itself the seeds of its own dissolution, if not amended by a Bill of Rights." In fact, the subject of amending the freshly ratified Constitution was so much in the forefront of the mind of the young nation that Washington, in his own first inaugural address, acknowledged it was inevitable. So the writing was on the wall from its inception. Assurances had been made to gain ratification of the Constitution that had to quickly be addressed. There were still those who did not agree with ratification, believing the document was too incomplete or insufficient to actually guarantee our liberties. George Mason was among those original delegates who remained opposed to signing the new framework because it lacked a, quote, Declaration of Rights. Among other things, Mason recorded and circulated the reasons for his objections, and that document became the foundation for what has become known now as our Bill of Rights. Mason and a couple of his colleagues at the 1787 convention weren't the only ones reluctant to approve the new Constitution without a guarantee of the protection of individual liberties. The lack of a Bill of Rights became a sticking point during various state ratifying sessions. And in order to secure passage, the Anti-Federalists were promised that a list of enumerated rights would be considered during the very first Congress. It was none other than James Madison, originally a staunch opponent of such an addition, who would champion the cause. Freedoms of speech, press, religion, the right to assemble, bear arms, due process, and so on, you know them well. And though they've since been debated time and again, their application to specific situations, how that should play out, they are as fundamental to us and now as any part of our Constitution. Can we imagine a U.S. Constitution without specific enumerated rights? Yet it took nearly 3 years after the Constitution was ratified for these principles to become part of our permanent infrastructure. In the end, 10 of the 12 proposed amendments were ratified by 3/4 of the state legislatures, and we had the Bill of Rights. It was secured. But that was not the end of those early proposals. More than 200 years later, one of the two originally proposed amendments that was left on the cutting room floor in those early years was passed and became the 27th Amendment to our U.S. Constitution in 1992. Think about that. A law that was proposed as one of the original package of amendments that became our Bill of Rights was regarded just as relevant in 1992 as it had been 200 years prior. The cause of securing specific liberties to the people did not end with those first 10 amendments. There were greater debates coming concerning the reach of freedoms secured by the Bill of Rights. Because while the Bill of Rights placed more limits on the reach of the federal government, many questions began to arise about its application to the states. It's an early example of the boundaries of our system being tested, as they have and will continue to be. The 14th Amendment, together with subsequent opinions by the High Court, extended the Bill of Rights to apply to the states, but only after it had handed down a series of opinions that originally rejected that application. While the High Court initially held the 14th Amendment did not constrain the states, for example, the Cruikshank decision in 1876, the court eventually began to stretch the application of the 14th Amendment's due process clause through incorporation. But if you look over the history, the court wrestled with this, whether and to what extent the 14th Amendment secured these rights to people over the objections of the states. Author and political science professor Richard Kortner has noted that in a number of decisions between 1870 and 1900, the court held the Due Process Clause did not require states to abide by provisions of the 5th, 6th, and 7th Amendments of the Bill of Rights. He points out that although it was ratified in 1868, the court did not accept that the Due Process Clause extended protection of these rights against actions of the states until a case in 1897. In that case, Kortner writes, the Supreme Court for the first time held that a right in the Bill of Rights was also a limitation imposed on the state and local governments by the Due Process Clause of the 14th Amendment. Another of the most dramatic and impactful reversals in the Supreme Court's history came in its decision in Brown v. Board of Education. You will know it well. It repudiated the separate but equal doctrine laid out in Plessy v. Ferguson in 1954, a nearly 60-year-old precedent that put a government-sanctioned stamp of approval on segregation was finally overturned. In Brown v. Board, the court found that the 14th Amendment prohibited segregation. And though coming more than 160 years later, one of the most glaring shortcomings of the U.S. Constitution was finally rectified. In between those events, though, the legislative branch stepped in again and again, trying to correct an injustice. Through the passage of the 14th Amendment together with the 13th, a wrong was finally righted, and these two acts of Congress working together with the state legislatures fundamentally nullified Dred Scott, a decision considered among the worst ever handed down by the U.S. Supreme Court. So finding the right balance and securing critical rights has been a journey, with the court finding its way around how to do things like apply free speech, free exercise of religion, the right to assemble, right against self-incrimination, just to name a few. And it's an ongoing process. As new circumstances arise, the court is charged with reaching the right application in the objective of safeguarding our fundamental liberties. Free speech, one of the main protections laid out in the very first amendment added to the Constitution, was drafted by James Madison, drawing on the Enlightenment thinkers. Madison borrowed from John Locke and Voltaire. In fact, Madison's argument in 1789, while introducing the Bill of Rights, the amendments, strongly reflects this influence. He said, "The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments. And the freedom of the press is one of the great bulwarks of liberty shall be inviolable." But how to balance free speech with other essential ingredients of a civil and orderly society left some open questions as our nation grew. Writing for a unanimous court in 1919, Schenck v. U.S., Justice Oliver Wendell Holmes said that free speech is not absolute. He said a new clear and present danger standard, quote, "The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree." He wrote in that case, The court ruled that the Espionage Act did not violate the First Amendment owing to the circumstances of speech occurring while the nation was at war. There were decades of gradual interpretations of the court, giving way to the Brandenburg decision in 1969. In it, the justices articulated the imminent lawless standard, replacing the clear and present danger standard. That per curiam opinion said that the Constitution guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. There was not a straight line between 1919's clear and present danger standard and 1969's imminent lawless action. In the intervening 50 years, the court meandered a bit, to be frank, trying to find the right test that would protect the integrity of the First Amendment. And by the time Brandenburg came before the High Court, the 1919 standard had been so twisted and confused that free speech protections were far from the core mission, that a clarification was in order. The court made it harder for the government to suppress unpopular speech, which we all know is the point. And while the Supreme Court continues to refine its approach to applying speech protections, the modern era now presents altogether new challenges with advances in technology, certainly ones the founders could never have contemplated. In 2014, the court unanimously reversed a lower court when it ruled that police generally may not search a person's cell phone for digital information when they're arrested without a warrant, upholding the Fourth Amendment protection against unreasonable searches and seizures. More recently, we've seen the High Court venturing into the rights and responsibility of social media platforms. And reaching even further into our future, which feels like the present, the federal courts are knee-deep in considering the rights of artificial intelligence. If I didn't have your attention before, maybe this will strike at something more immediate for our audience. In a very unique case whose eventual conclusion could have widespread application, a federal court right now in Florida is being asked to determine whether AI chatbots enjoy free speech rights extended to humans by the First Amendment. In that case, a mother filed suit after the suicide of her son, which she said followed her son expressing thoughts of self-harm to a bot. Just days ago, another family filed a lawsuit alleging that ChatGPT had advised their son on methods for taking his own life and even offered to help him draft a suicide note. The 9 justices will likely be called on in the very near future to apply the principles laid out in our Constitution and its amendments almost 250 years ago to some very modern problems. In the High Court's more immediate future is a flood of emergency action related to challenges of President Trump's executive actions. In a recent piece that he wrote for the Free Press, Jed Rubenfeld, constitutional law professor at Yale, argued that President Trump has been in compliance, he says, with court orders, even as he attempts to find workarounds, much as President Biden did when there was a decision he didn't like, for example, on student loan forgiveness. And as evidence, Rubenfeld points to the Trump administration's numerous appeals to the justices, settling or asking them to. These heated debates, I can frankly hardly keep track. The calendar changes day by day. One thing is for certain, as has been the case throughout our history, this is not the first time that American citizens have looked to the courts and to Congress to serve as a check on the executive. This, too, was contemplated from the very beginning. And as King Solomon wrote in Ecclesiastes, there's nothing new under the sun. Extraordinary events involving the tension between the Supreme Court and the president have become a part of the testimony of the U.S. Constitution's strength. As early as 1804 and clear through to the present, the court has served as a check on a number of presidents: John Adams, Abraham Lincoln, Andrew Johnson, Harry Truman, and yes, Presidents Biden and Trump more recently. In perhaps one of the court's most famous showdowns with a president, the court ruled unanimously against Richard Nixon's claim of executive privilege in 1974. So you and I may agree or disagree with the court's decisions when it comes to the boundaries of executive power, but what is actually amazing is that that check even exists in the first place. During the late 1700s and 1800s, such a system was a rarity on the global stage. History to that point generally tended to an all-powerful executive found in an absolute monarch or an emperor. The U.S. Constitution was among the very first modern examples of a national written constitution that specifically constrained the exercise of executive power. And it remains one of the very few systems that has been successful in maintaining this balance over such a long period of time. Our Constitution has stood firm among constant change, growing, evolving, addressing challenges that remained from the very start of drafting the Constitution and adopting it in its imperfection. It should not worry us that we continue to make changes, witness reversals, adopt amendments, and propose more as we venture into uncharted territory. I believe we should take great comfort, not fear, in the fact that our Constitution was constructed to be able to not only withstand, but also to incorporate change. The challenges remain, that is certain. But if past is prologue, I have every confidence that this magnificent document that has guided and safeguarded our liberties for the past 250 years is capable of seeing us through the next 250. A big part of my confidence is because of groups like this, of people like you. I think you're here today because you want to be a part of a conversation about how to better our Constitution, our understanding of it, and to protect its unique and powerful legacy. As a person of faith, I'm deeply grateful for the First Amendment's language, both banning the government from telling me what religion I must adhere to and ensuring that it cannot trample upon my exercise of the one that I have chosen. My faith as a Christian calls me to repentance and forgiveness, a framework for me taking responsibility and for making wrongs right. I believe that our founders knew even our most cherished document, laying out freedoms for some, but wrongfully, not for all, would also need a structure that would enable us to improve upon it. Knowing that they themselves were imperfect, they built a way for us and every new generation to improve upon where they started. And that's something that required humility from them and now requires it of us. Checks and balances among the three branches, an explicit enumeration of individual rights, just the right framework to be pliable enough without breaking. It's all the result of hard-fought compromise. So let us now not forget the precious value of compromise or of humility as we try to find ways to bridge our differences and work toward a more perfect union with the Constitution as our guide. Thank you.